So it is the constitutional mandate, constitutional obligation, constitutional duty enshrined under the preamble of the Constitution, already with Part 3 and Part 4, that the welfare of the people of this country is paramount importance for the state. State is defined under Article 12 of the Constitution of India. State is central government, state government, instrumentalities, and the companies or corporations which are under the control of either the central government or the state government. State includes the judiciary. This is very, very important. The Constitution provides, envisages three limbs of the Constitution: legislature, executive, and judiciary. So legislature, parliament, state legislative assembly, they will enact a law for governance under the Constitution in respect of their jurisdiction, exercising their legislative power from the entries list 1, list 3. Sometimes during emergency, the list 2 entries also invoked by the parliament for the purpose of enacting the law. So the central government, the state includes the central government, state government, instrumentalities, and corporations owned by central government, state government, for the purpose of discharging their constitutional function, give good governance to the people of the country. What is the good governance is envisaged in Part 3 and Part 4. The equality concept is very much there. Public employment is provided in Article 15. Educational reservation to the backward class people is provided under Article 15. Educational, 17 untouchability is provided. All that may not be necessary. But I am only telling that the Article 21, 23, 21 means life includes livelihood. This is what has been held by the Supreme Court in Olga Tellis case in a public interest litigation. Olga Tellis is a journalist. He has filed a petition under Article 32 with reference to the slum dwellers who are vending the vegetables and other small items for the purpose of their livelihood in Mumbai, Maharashtra state. So that case, when they were about to be evicted, the Olga Tellis went and urged that this is arbitrary action, violation of Article 14, 19, occupation, 21. All these aspects were argued. Justice Chandrachud has expounded the law and referred to the judgment of the apex court of the America at paragraph 32. He has lucidly laid down the law. Life includes livelihood. For livelihood, there must be a source of income. For source of income, there must be, if there is no source of income is deprived of, it amounts to denuding the liberty and denying the liberty of an individual. Liberty is the basic structure of the Constitution of India. So therefore, Part 3 is applicable to all 133 population of this country, except certain exceptions with regard to non-citizens. Citizens issue is pending. That is a different matter which I don't want to deal with that matter. So therefore, we must keep in mind preamble of the Constitution, the justice, social, economic, and political. In addition to that, in Bhagavati, in this case, what is called People's Union for Democratic Rights case, in the year 1982, profoundly laid down the principle that weaker and vulnerable section of the people, anybody on their behalf file a petition, Article 32. The technical objection raised by the Delhi government, Delhi Development Authority, and Delhi government and central government was negated. So the Supreme Court in that case has said, we must, the courts are not only meant for only the people who have, it must also be for the have-nots. The Supreme Court has said that at paragraph 2, it has said, the poor too have civil and political rights, and the rule of law is meant for them also, though today it exists only on paper, not in reality. If the sugar barons, please listen, this is very, very important. You must be fascinated by these words which are used by Justice Bhagwati in that case. If the sugar barons and the alcohol kings have the fundamental right to carry on their business and to fatten their purses by exploiting the consuming public, have the business by exploiting the consuming public, have business, and to fatten their purses by exploiting the consuming public, have the chamars belonging to the lowest strata of society so fundamental right to earn an honest living through their sweat and toil. The farmer can approach the courts with a formidable army, distinguished lawyers paid in 4 or 5 figures per day, and if their right to exploit is upheld against the government under the label of fundamental right, the courts are praised for their boldness and courage, and their independence and fearlessness are applauded and acclaimed. But if the fundamental right of the poor and helpless victims' injustice is sought to be enforced by public interest litigation, the so-called champions of human rights frown upon it as waste of time of the highest court in the land, which according to them should not engage itself in such small and trifling matters. Moreover, these self-styled human rights activists forget that civil and political rights, priceless and invaluable as they are for freedom and democracy, simply do not exist for the vast masses of our people. Large number of men, women, children who constitute the bulk of our population are today living in a subhuman condition of abject poverty. After grinding poverty has broken their back and sapped their moral fiber, they have no faith in the existing social and economic system. What civil and political rights are these people, deprived sections of humanity, going to enforce? This was brought forcibly by W. Paul Gormsley in the Silver Jubilee celebrations, etc., etc. These are the observations made by Justice Bhagwati in that case. And further, he has quoted Mahatma Gandhi, and he has said, there are 2 passages I wanted to read for your consideration. In the same judgment at para 3, he has referred to the millions of persons belonging to the deprived and vulnerable sections of humanity are looking to the courts for improving their life conditions and making basic human rights meaningful for them. They have been crying for justice, but their cries have so far been in the wilderness. This is what exactly is happening today in relation to the 11 crore migrant workers for the last 2.5 months. Even now, I was seeing in the big field, the people were made to sit, identify them, check them, issue the identification cards for traveling to their respective, they're all migrant workers. This is the position even today. The People's Union for Democratic Rights case is a case of Asiad, famously called as Asiad Game case. They're all migrant workers involved in construction of Asiad Game Stadium. They have been, in this context, he has referred to Mahatma Gandhi. He has said, in just silently with the patience of rock, without strength even to shed any tears. Mahatma Gandhi once said to Gurudev Thakur, this is very important, please listen. I have had the pain of watching birds who for want of strength could not be coaxed even into a flutter of their wings. The human bird under the Indian sky gets up weaker than when he pretended to retire. For millions, it is an eternal vigil or an eternal trance. This is the true of the human bird in India even today, after more than 30 years of independence. The legal aid movement and public interest litigation seek to bring justice to these forgotten specimens of humanity who constitute the bulk of the citizens of India and who are really and truly people of India. I hope and trust all the constitutional courts, the apex court and Supreme Court will refer to this judgment, refer to the Mahatma Gandhi. Mahatma Gandhi, the father of the nation, who took lead to liberate the country from the colonial rule. And we became Republic of India. Dr. Ambedkar gave the chairman chief, who was the architect of the constitution. Under his chairmanship, it was drafted and accepted. We became Republic of India. Part 3, preamble, Part 3 and Part 4 rights are given to the people of this country. Now, 30 years, what was the plight to the Asian migrant workers is much more worse than today after 72 years of independence in India. Therefore, the state, the central government, the state government, local self-government, state, the judiciary, the part of the state, must keep in mind that if the state fails, that is central government, state government, local self-authority fails, you must step in, because we are required to protect the human rights of the people of this great country. Then only there will be rule of law. Supreme Court in caton of cases, constitutional bench after constitutional bench judgment, have ruled that rule of law is the basic structure of the constitution. In the Keshavananda Bharati's case, I tell you, Keshavananda Bharati case, Indira Gandhi's case, that is 1975, the Minerva Mills case, and additional district magistrate Jabalpur, that is the ADM Jabalpur case, which I referred to in my article, that judgment has been overruled. Khanna judgment, the dissenting view, has become the majority view in the Puttaswamy's case, 2017. The Supreme Court, in all these judgments, has said what are the features of the basic structure. We must give loud thinking. We must give our attention to these aspects where the law has been profoundly laid down by the Supreme Court. In Keshavananda Bharati's case, more than 2.5 months the argument went on. Great lawyers of this country, the Solicitor General, Solicitor Attorney Generals, Solicitor Generals, and private lawyers, Palkiwala, Nerende, so many people have argued this case. The Supreme Court 13 judge bench, though it is 6:7, the law is that what is basic supremacy of constitution. So this judiciary being part of the state, if the central government, state government, local government failed in a situation like this to protect the human rights of the people of vulnerable society, the supremacy of the constitution must be upheld. That is very important. Otherwise, we are not following the binding precedent in Keshavananda Bharati's case. A Republican and democratic form of government. So this is a Republic India. Democracy is also a basic structure of the constitution. Democratic form of government. Government is by the people. Sovereignty is given by the people in democracy. By the people, for the people, of the people. Now you are being given mandate to rule. You may be the majority or minority government, but you are the government. It is the central government, state government, local self-government up to 73rd and 74th Constitutional Amendment during 92-93. So therefore, you must remember, particularly the legal fraternity, the lawyers, particularly the constitutional functionaries sitting in the apex court and the high courts, must remember that this is the Republican and democratic form of government, secular character of constitution, separation of powers between legislature and the executive and judiciary, and federal character of the constitution. Federal feature of the constitution is emphasized again and again in Keshavananda Bharati's case. So these are the 5 cardinal principles which have been highlighted, laid down, the features of the basic structure of the constitution. Basic structure of the constitution cannot be amended by the parliament, is the law in Keshavananda Bharati's case and Bommai's case. Now, What is this? This you must
सही
keep
बात
in
है।
mind. Article 39, capital A. Before that, Article 38 in the Directive Principles of State Policy. What is that Article 38? State shall endeavor to secure social order. Social order means what? It is not law and order. It is not pandemic. Police people are taking, regulating, don't move in two-wheel or three-wheel or four-wheel, social distance, community distancing. That is not social order. That's not the law and order. Article 38 is the social order. Social order means, in one of the judgments, Justice Krishna has said during 1978, with reference to Article 78, he said, it is unless you render economic justice to the people, vulnerable sections of society, that is not, you will not secure social order. To secure social order is the constitutional mandate and obligation function of the central government and state government, including, if they fail, separation of power under Article 50 is very much there. Separation of Article 50, I'll deal with that little later. Now, separation of power is also a basic feature of the Constitution. Article 38 is social order, means economic order, it is not law and order. Thereafterwards, the parliamentarians felt that Article 38 itself is not sufficient. 39, A, B, C, D, E, F is not sufficient. Equality, equal the opportunity, material resource for the common good, etc., etc. That is not the matter which I don't want to deal with now. They felt that 39A, this equal justice concept was provided by amending the Constitution, 42nd Constitution Amendment, with effect from 3/1/1977. 39A says, the state shall, 42nd Constitution Amendment, the state shall secure the operation of the legal system, more particularly applicable to the legal system, the judiciary, legal system, the judiciary, law, legal fraternity is a part of the legal system. Justice system promotes justice. What justice? Socio-economic and political preamble. Justice on a basis of equal opportunity. Equal opportunity for what? Equal opportunity for education. Equal opportunity of livelihood. Equal opportunity for education, health, residence, material resource, all must be equal opportunity, must be given to have the public employment or other employment for the earning livelihood. To see that meaningful interpretation 21 in Ketanov cases, it has been said, life includes livelihood. The equal opportunity and shall in particular provide freely paid by suitable legislation or schemes or any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic and other disabilities. These articles should have been pressed into service 2 months back itself by the constitutional courts in this country, when migrant workers were governed of the Migrant Workers Act of 1979, when breakdown by in exercising power under the Disaster Management Act, both under Section 6 and Section 10 by the Home Ministry of the central government, and there was no work for them, there is no shelter for them, there are no wages for them, there is no food for them, they have no health, there is no health for them, the children have no education. These people decided we wanted to go back to the native places, their respective states. Please make arrangement. Central government kept mum. State government kept mum. Because breakdown. After the breakdown was little relaxed, then central government, state government said, we will provide them their travel expenses, 85%. Now, I am only telling with reference to Article 39A, the legal system, when on their behalf, the action group, a public spirited NGO, which is espoused by Prashant Bhushan, first public interest litigation. Second interest litigation, some NGO filed. The Supreme Court should have taken note of the fact that Solicitor General says that no migrant worker on road. This is a statement on record. So, the constitutional courts, while dealing with the public interest litigation, you are required to keep in mind the preamble, justice, socio-economic and political, particular to the vulnerable section of the people. The justice is the basic structure of the Constitution, and it is the legal system must promote justice to the have-nots, vulnerable section of the people. That is why 39A should have been invoked, read with 32 and preamble of the Constitution and basic structure of the Constitution. That has been failed in this court. Of course, now they have initiated the high courts in India. Even after the two petitions were dismissed by the Supreme Court, Gujarat High Court, Andhra Pradesh High Court, the Karnataka High Court, Tamil Nadu High Court, all these constitutional courts have exercised their power under Article 226 of the Constitution of India. In relation to these people, Solicitor General made a scathing observation before on last Thursday the Supreme Court. Such state of affairs. When they have exercised their constitutional power under Article 226, extraordinary jurisdiction, keeping in view the obligation upon them to see that having understood the constitutional philosophy and the constitutional concept of preamble and the direct principle of state policy in the part 3 and 39A particularly, and they issued the Solicitor General made a scathing remark. They are running parallel governments. I am sorry to make an observation. Solicitor General, being the officer of the court, should not exceed his limits in attributing certain motives to the constitutional judges who have functioned and discharged within the parameters of the Constitution. The Solicitor General also, I hope and trust that he must understand and give effect to the law laid down by Supreme Court in Keshavananda, Indira Gandhi's case and other cases which I just now referred. Forgetting those, the binding precedents, Solicitor General being the representative of the central government, he thought that only opposing public interest litigation before the Supreme Court to go to the rescue of the people and protect the human rights and civil rights and political rights of the vulnerable section of the people. In such state of affair, this is no citizen, no ordinary person, a common man can expect such kind of statement by Solicitor General before the court. When these constitutional functionaries are not before the Supreme Court, you bully them. You make attribute motives to them. But they are the parallel government. Who said they are parallel government? You must understand that central government, state governments have failed miserably. This is expressly clear. 400, 500 people died. One mother died in Muzaffarnagar. That baby was going around the dead body. Are you not aware? The electronic media. He has made scathing attack against the journalism. Today in Hindu newspaper, serious attack without knowing the responsibility, criticizing, commenting, journalists criticizing, commenting the constitutional functionaries, the High Court judges for having exercised constitutional power. So this Article 39A, according to me, even in Hussain era Home Secretary Bihar 1979, Supreme Court has said a person legal aid, interpretation of Article 21, speedy justice must be given. That is also a public interest litigation. Now, my dear friends, I am going in detail with regard to this. Let us understand what is public interest litigation. What is the definition of public interest litigation? Public interest litigation has, first of all, it is not a traditional approach adversarial system of litigation. The locus standi issue as well as the aggrieved person does not arise in the public interest litigation. The Supreme Court, in Australia, for protecting the environment, they said, not only in Australia, the Australian High Court has said, in Gupta's case, SP Gupta's case, we have said locus standi cannot be raised. Agreed, if locus standi cannot be the issue in a public interest litigation, not only in that Gupta's case, Fertilizer Corporation case, Railway Karmachari Sangha case, number of cases from 1981 onwards, Supreme Court, one after the another, they have laid down the aggrieved or locus standi traditional type of litigation. Aggrieved person only must come. That has been negated in People's Democratic Rights Asiad Games case. And in Australia, they have said protecting environment. The Australia High Court has diluted the principle of aggrieved person. Public interest litigation has been a method of protecting environment. Environment, in respect of that, there is a voluminous case law ruled by the Supreme Court, which I am going to deal with, Mehta versus Union of India, in number of cases, which I am going to deal with that. Now, what is public interest? What is the definition of public interest? There is no definition here, but the public interest litigation, according to Black's Law Dictionary, which has been considered by the Supreme Court in state of Uttaranchal, Balwant Singh Chopal, that's Advocate General appointment, was present. In Threadbare, what is public interest litigation? What is locus standi? What are all the aspects? What is the contours of public interest litigation? What is jurisdiction from the High Court? All these aspects have been referred to in the Uttaranchal, state of Uttaranchal, that is 2010 3 SEC judgment, page 402, has been elaborately dealt with by the Supreme Court judge. Public interest, according to Black's Law Dictionary, something in which the public, the community at large, has some pecuniary interest or some interest by which their legal rights or liabilities are affected. It does not mean anything so narrow as mere curiosity or as the interests of the particular localities, which may be affected by the matters in question. Interest shared by citizens generally in affairs of local, state, or national government. This is the definition, this is the meaning of the public interest according to Black's Law Dictionary. According to Advanced Law Lexicon, it is defined, public interest litigation means. The expression PIL means legal action initiated in a court of law for the enforcement of public interest or general interest, in which the public or a class of community has pecuniary interest or some interest by which their legal rights or liabilities are affected. The Council for Public Interest Law, set up by Ford Foundation in USA, it defines public interest in its report. It says, public interest law is the name that has recently been given to efforts providing legal representation to previously unprecedented groups unrepresented groups and interests. Such efforts have been undertaken in recognition that ordinary marketplace for legal service fails to provide such services to significant sections of the population and to significant interests. Such groups and interests include proper environmentalists, consumers, racial, ethnic minorities, and others. This is what is been approved by the Supreme Court in the case of Info Pictures Private Limited versus Prem Chandra Mishra, 2007, 14 SCC 281. This is the law with reference to the foundation report, which has been elaborately referred to in this case. Even in the People's Union of Democratic Rights, that is Asiad Games case, public interest is defined and observed in the 82 Supreme Court, that is 82 SCC page 235. It has said, it is observed, public interest litigation is a cooperative, collaborative effort by the petitioner, the state or public authority, and judiciary to secure observance of constitutional or basic human rights, benefits, and privileges upon the poor, downtrodden, and vulnerable sections of the society. So this is the basic understanding of the public interest litigation. Now, answer to Solicitor General argument, the other constitutional courts have become parallel governments. He has forgotten Article 50 interpretation made by the Supreme Court. 50 under the Part 4 of the Constitution of India, separation of powers. The states shall take steps to separate the judiciary from executive in the public services of the state. For that, separation of powers in the Supreme Court, University of Kerala versus Council Principals Colleges, Kerala, AR 2010, SC 2532, Supreme Court has held separation of power. That means the executive and the judiciary. Yes, there is a separation of power. Who said no? Judiciary is independent and vibrant. Yes. Who said no? The High Court is a constitutional court. They can exercise power in 226. Apex Court under Article 32 to enforce the fundamental rights there. Insofar as the High Court's constitutional courts are concerned, more power than the Supreme Court. It is not only infringement of the fundamental rights, also violation of the statutory rights. In case of migrant workers, the central government and state government have blatantly violated the statutory rights, migrant workers' rights, minimum wages, Industrial Disputes Act, service conditions, Payment of Wages Act. You have violated. You have not been provided shelter in a subhuman condition. They have become destitute. They were sleeping on the streets. This you must understand. If they entertain the public interest litigation, you have got the audacity to say that they are the parallel governments. Why parallel government? The central government and state government have failed in discharging their duty to send them to their respective places, provide them job, provide them shelter, provide them food. What more is required? Is it blatant, not for blatant violation of the human rights, Part 3 and Part 4? What is wrong? You have failed. Your inaction made the public spirited persons going and filing a petition in the High Courts and Supreme Court. What is wrong with that? How can you attribute it is a parallel government? You must understand the judgment Supreme Court 2010 in University of Kerala versus Council of Principals, separation of power has to be viewed through prism of constitutionalism, democracy, constitutional philosophy, and the concept of the socialism, justice, the social, economic, and political rights of the people of the country. So, and for upholding goals of justice in its full magnitude. What is wrong? I hope, I request the Solicitor General to have look at the judgment of the Supreme Court and interpretation made by the Supreme Court with regard to separation of powers. Despite the judgment of the Supreme Court, is it overruled? This judgment is overruled the Supreme Court? How can you say attribute they are parallel governments? Exercise the public interest litigation. So therefore, my dear friends, the public interest litigation has to take the legal fraternity, committed lawyers, social activists must render legal aid to get equal justice as envisaged under Article 39 capital A of the Constitution of India. The legal system must render justice. Legal system is the judiciary of this country, for which the lawyers and the All India Lawyers Union is committed to socialism, democracy. Am I correct, Mr. Surendranath? So, you are wedded to socialism, democracy, and rule of law. Correct?
Yeah, definitely.
So therefore, the relevant topic chosen by this All India Lawyers and Delhi Union is very apt at this present time, and all the lawyers, whatever the law has been developed, right from 1970 onwards, 75 onwards, now it must take different dimension today, keeping in view that we are seeing only 3 crores litigation in the rural parts of India. A rural based economy, agriculture based economy, rural parts of the country. 70% of the population live in rural India. Therefore, today you must know that each village is a slum. All mud roads are there in the village, every part of the country. People who are living in the area, the rural area, 70%, who are agriculturists, agricultural laborers, they don't have the proper housing. They don't have the drinking water. They don't have proper the facilities. So therefore, you must keep in mind, no drinking water during the summer. During the floods in Kerala, in Karnataka, a recent cyclone, South Patanganas, lakhs of people have been displaced. What is the 1,000 crores announcement by the central government is sufficient? How many lakhs of people are affected? How many lakhs of crores of rupees is destroyed on account of this cyclonic effect? Now, North Parangana, it is spreading to Maharashtra and Gujarat. Therefore, today it is not between the plaintiff and respondent defendant case. It must be the petitioner social action group to take up the issue of people who have no access to justice. Article 39A envisages access to justice. Access to justice to the millions and millions of the people of this country. In this country, unorganized sector, more than 50% of people, youth are unemployed, women are weaker sections of society. Today, in the rural India, no proper road, no proper electricity. The food grains they grow, they will not get the market even though APMC market is there. In respect of those people, drinking water is held to be the human right. Supreme Court has said, repeatedly said, without water, on account of arbitrary allowing in the name of sustainable development, in Orissa state I was the Chief Justice. In Bangalore city I am presently residing. Within 10-15 kilometers of the city there are industries. The effluents of the industry. Hospitals, hospital corporation waste is being the sewage. The effluent the sewage, big sewage, and some in Yamuna water. There is a judgment of Supreme Court 1985 rural litigation case. So I am on the point. Today, the lawyers and action groups, the committed people who are defending the rights of the citizens of this country must expose more number of public interest litigation both in the Supreme Court and the High Courts for redressal of the grievances of the people. 72 years of the independence, India. What is the position today? How many primary health centers are provided? In Kerala state, 3 crore population, the 800 primary health centers they could able to manage the COVID-19. In Gujarat, 7 crores population, what is the infrastructure? 700 primary health centers. That is why the people are suffering and deaths, more deaths taking place there. How many primary health centers in which taluka and the district and the cluster of gram panchayats were provided? The Supreme Court interpreting Article 21. I am not speaking only the weaker section of society. Even people who are holding 100 acres of land, even he can't go and take the treatment in a corporate sector hospital, nursing homes today. In the absence of primary health center, when interpretation of Article 21 is interpreted, that the life means it is not an animal existence. It is not, it means a healthy life. When people are suffering from cancer, people are suffering from the coronavirus, where are the hospitals? Where is the oxygen cylinder? Where are the masks? Where are the PPE provided to the doctors, nurses, attenders? What is happening? Now it has crossed more than 1,10,000. Yes, compared to America, your figure is low. But how many tests you have conducted? I am on the point. In today, the public interest litigation must be entertained. It is not a multinational company writ petition, company corporate sector writ petition, or a person who is a IAS officer's writ petition, landed person's property SLP. The SLP, how many? More than 60,000 cases may be there. But how many? What is the population? 3 crore and 4 crores litigation, both criminal and civil, in the entire district judiciary of the country. Now, do you mean to say that other people don't have the problem? Are these not problem? No road, no health, no private centers, no government schools. You have privatized the education system. Education 21A and Act is also held to be constitutionally valid. Today, teachers are not appointed. Universities, colleges, the academicians are, the lecturers are not appointed. Ministry staff is not appointed. These are all without the lecturers and professors. How can you run the education institution? Without giving education, how can you say that my country is growing, developing? Do you know? I will give the statistics. What has happened during the 72 rule of the successive governments in the country? I'll tell you. I'll give the statistics figure which I told day before yesterday to the press people here. I have got statistics. According to WHO, for health, 3.2 budget allocation must be allocated for the people. What is that you are doing? You are less than 2.3 budget allocation. Now 6 point and odd must be allocated for the education. It is very minimal amount is allocated. What is, despite 72 years of the independent country rule, the illiteracy is so rampant, except in certain states, particularly Kerala state and other state, which I am really not in a position to tell you. 50% of the people are illiterate. They don't read and write. This is the plight after the independent India, 72 years of rule. So this is the area where we require public interest litigation to be promoted, initiated. Now, I hail from a district where water is not available, no rain at all, rainfall. Why rainfall? Forest is devastated, forest is destroyed, forest lands are given for the mining. The miners have been exploiting thousands of hectares of land. The mineral has been extracted. When the forest is destroyed, rainfall has come down, no minor irrigation is developed, no ponds are there, ponds must be protected, lakes must be protected, is the fundamental duty guaranteed under Chapter 4A, but that has been a go by. So, this has to be checked. The arbitrary exercise of power for extraneous considerations. There is also the Supreme Court has dealt with in relation to public interest litigation is not necessarily to the vulnerable section of the people and also for the benefit of the people of this country. The Supreme Court in number of cases it has been held. I'll tell you that in Sachidananda Pandey's case, state of West Bengal, way back in 1987, the Supreme Court has observed the public interest litigation should be encouraged when the courts are appraisal of various gross violation of fundamental rights to a group of class of action. When human rights are invaded, such acts should not be judicial conscience. If the fundamental rights blatantly violated, does it not shock the conscience of the courts? The courts, especially the Supreme Court, should leave aside procedural shackles and hear such petitions and extend its jurisdiction of all available provisions for not remedying hardships and miseries and needy, the underdog and the neglected. You please see this. This is one aspect. Another is in the case of Vishaka, where woman has been working in the working place, sexual abuse is not covered by the judgment. Supreme Court has entertained the petition by Vishaka. It gave directions to the enforcement of fundamental rights of working women under Article 14, 19 and 21 of the Constitution. Court give comprehensive guidelines, norms directed of protection and enforcement of these rights of the woman in the working place. With regard to the environment, air is polluted, water is polluted, the industrial effluents are left to the sewage, and that will go to the underground water. The water now we are getting from the underground by bore wells. These minerals which are thrown into the sewage and wastage exposed to the air, and air is polluted, water is polluted, water we are drawing from the ground level is polluted water. It contains sulfur, it contains phosphorus. Disabled people are born because of the drinking of this water and the inhaling this sulfur which contained in the air. Supreme Court in the case of Vellore Citizens Welfare Forum, the court has held the precautionary principle and the polluter pays principle are part of environmental law of the country. You know, recent incident in Visakhapatnam, that LG polymers is a poisonous gas. During a breakdown, they did not maintain the temperature. They could not maintain the temperature. When they went there, it should have bursted, and all gas was emitting. The residents, thousands of people were affected, animals were affected, and people, more than 50 people died. The people were still suffering. Animals, sheep, goats, the cow, eggs, all died. So the Supreme High Court exercised its power, so moto taking the power to protect the interest of the people. So therefore, their air is polluted. Poisonous gas was inhaled. The public interest litigation is still pending in Andhra Pradesh High Court. With regard to the environmental aspect, Supreme Court has said polluter must pay the penalty, damage to the people. Principle or part of the environmental law of the country, that is, polluter pays principle or part of the environmental law of the country. The Supreme Court in that Vellore citizens case declared Article 47, 48A, 47 and 48A and 51AG are the fundamental duties to be part of the constitutional mandate to protect and improve the environment. Again, this is in the year 1996, Supreme Court 5 SCC, page 647. In Mehta's case, Union of India, the Supreme Court has held the effluent discharge in River Ganga from a tannery is 10 times noxious when compared with the domestic sewage water which flows into the river from an urban area on its banks. The court observed the financial capacity of the tanneries should be considered as irrelevant while requiring them to establish primary treatment plants, just like an industry which cannot be minimum wages to its workers cannot be allowed to exist. A tannery which cannot be set up a primary treatment plant cannot be permitted to continue. This is when these tanneries are allowed, that the effluents to the river Ganga, it is polluted. People have suffered. Supreme Court said, unless we establish a plant, this is treatment plant, you cannot continue the tannery industry. Again, in the case of Mehta versus Union of India, that is in the case of 97 Supreme Court, it has said that in Taj Mahal case, the case still the Taj Mahal, if you go there and see, you will see an account of this tannery. It is observed the preserve protect the ancient monument of Taj Mahal from sulfur dioxide emission by industries near Taj Mahal. So now the air is polluted, water is polluted. Now the Central Pollution Control Boards are there. These people are not regulating. That is because they are taking care of their interest. I can't understand. Instead of protecting the millions and millions of the people who are residing nearby these ancient monument and near River Ganga, these people are allowed to carry on with their industry. So Supreme Court has said that they observed 299 industries near Taj Mahal to ban use of coke and coal. The court further directed them to shift over the compressed natural gas to relocate them. And in the case of AP Pollution Control Board versus Professor M.V. Naidu, the Supreme Court, if it's environment ethics, with reference to that, choices for concerned citizens, same is introduced as under the basic insight of ecology. It is said by Supreme Court that all living things exist in the interrelated system, not only the human beings, the animals, the birds, the dog, the wild animals. All living things exist in the interrelated system. Nothing exists in isolation. The world system is web-like. To pluck one strand is to cause all to vibrate. Whatever happens to one part has ramifications for all the rest. Our actions are not individual but social. They are reverberate throughout the whole ecosystem. This is the judgment, the Science Action Coalition from the environmental ethics. Further, court in that case further said Direction of the court should meet the requirements of public interest, environmental protection, elimination of pollution and sustainable development, ensuring sustainable, etc., etc. There are so many other aspects. Even in the case from Karnataka, they have said that the industrial area development, to establish industry, there must be environmental clearance. If it is not there, public interest litigation is initiated by Kenchappa. Now, APSRT Satyanarayana case and noise pollution in every city area, noise pollution is very much there because of using the loudspeakers. Apart from that, power looms in the residential area, the viewing community people, and thousands of power looms are installed in the middle of the city and the town and the village also. So noise pollution, air pollution, water pollution, all these aspects affect large number of people. It is not only the vulnerable section of society, the people surrounding these things happening, then the public interest litigation is maintainable. A number of judgments in this regard. Insofar as the public interest dimension is concerned, not necessarily the vulnerable section, not necessarily environmental aspect, the Supreme Court, way back in the year 98, transparency and probity in governance. The first case is Vineet Narayan case, Union of India. The Supreme Court in the year 1990 itself, the scope of the public interest litigation has been expanded. High Court also under Article 226, the directions to unearth corruption and maintain probity and morality in the governance of the state. The probity in governance is sine qua non for non-efficient system of administration and for the development of the country. And an important requirement for ensuring probity in governance is absence of corruption. This may be this broadly called third phase of the public interest litigation. One is vulnerable section, two is environment, third is with regard to transparency and probity of government, public interest litigation. That is the dimension. That is the new emergence. These are all the new areas where today the people must take up these causes and approach the constitutional courts. Courts are required to consider having regard to do equal justice and to see that the human rights of the people are protected. In fact, in the case of Center for Public Interest Litigation, Union of India, in the year 2006, that is 2006 SCC, Supreme Court held that calling upon a decision of the government, central government, to sell majority of shares in Hindustan Petroleum, the Corporation Limited, Bharat Petroleum Corporation Limited, to private persons without parliamentary approval or sanction as being contrary to and violative of the provisions of SO, Acquisition Undertaking in India Act 1974, Burma Shell Acquisition Undertaking Act of 1976, and Context Acquisition Act of 1977, the court upheld the petition and said, until statutes are amended by the parliament appropriately, you shall not transfer the shares of the public sector undertaking. This is also a public interest litigation. And further, Supreme Court has said, there are some cases where Supreme Court and High Court broadened the scope of public interest litigation and also ensure the governance of the state. There is transparency and extraneous considerations are taken into consideration, except the public interest. These are the cases regarding probity in governance and transparency in their administration, and to prevent corruption in public life dealt with by the courts. And further, in Chandra Kumar's case also versus Union of India, the Supreme Court has held Chandra Kumar's case, it has said, separation of powers as envisaged, that undermines the separation of power. The Supreme Court has said in Farina Swarup versus Union of India, that is 2008, A member of a bar of this court filed a public interest litigation seeking to declare various sections of the Prevention of Money Laundering Act 2002 as ultra-vires. They do not provide for independent judiciary to decide the cases, but the members or chairpersons will be selected by the selection committee headed by the revenue secretary, according to the petitioner. And the judgment in Chandra Kumar's case, they said it is the separation, it undermines the power of the separation of powers. So these are the areas, according to me, my dear friends. Today, the dimension of public interest litigation has 1,000 times has expanded. It should be expanded. Then only justice we can render to the people and to protect the fundamental rights guarantee. If the inaction attracts Article 14, action and inaction is the dimension of Article 14. What is required to be done by the responsible governments in this country and local self-government, if they fail, if they are not in a position to give education, if they are not in a position to give primary health centers, if they are not in a position to give the fair price, minimum support price to the farmers, if not in a position to pay the minimum wages, if you are not in a position to pay, give the housing, if you are not in a position to give the health facility, all these aspects are required to be drawn because the governments have failed to perform and discharge under the governance of under the Constitution of India. So therefore, the dimension of the public interest judgment where it has been laid down the law, the executive is not taking care and they are justifying their action. They are telling that it is a big country. We are now only few years we are in the administration. We are not responsible. That is no answer. You are required to provide good governance. You are required to discharge your constitutional functions. You must fulfill the aspirations and ambitions of the people of this country. If you don't do it, your action will be inaction. If there's no inaction, not taking formulating the schemes and the policies, implementing to give effect to the Part 3 and Part 4 rights to the people of the country. So therefore, I am of the view that the public interest litigation must be encouraged because Article 39A, because of the inaction and vulnerable section are suffering. Rural India people are suffering. There is the environmental aspect. There is a probity aspect. There is this lot of corruption in the government and the public sector undertaking, which is the public property, public sector have been established. The means of control, means of production must be under the control of the state. Then only the preamble socialist, the meaning, it can be egalitarian system society to render social order to the people of the country. Then there will be welfare of the people. People will not die on account of the hungry. People will not die on account of financial disability. So many aspects. Farmers, lakhs of people are committing suicide. Why? You are one side, you give the wave of 67 lakh crores of money to the big industrialists in the country, including this Uttaranchal Swamiji. You don't lend money to the farmers. The banking industry is meant for only 67 lakh of course of people. Only the money to be industrial people, industrialists, but not to the agriculturists. Agriculturists, because they are not getting minimum support price. Though Swaminathan in the year 2010, he has submitted his report on the basis of various aspects, and he said that minimum support price must be given from 2010, 2020. Minimum support price is not given. Who has taken up the cause of the farmers? We are not paying minimum support price. Only we waiving off their small loan of 1 lakh or 2 lakhs. The big hue and cry is being raised. So therefore, these are all the facets, the new emergence of the public interest litigation. I hope and trust All India Lawyers Union and other people take up this cause and render justice to the people. I wanted to give you the certain aspects with regard to. Yes, Mr. Surendranath, can you now 5 o'clock?
In. It is 5:15. You can go back, carry on. Okay, okay. You can carry on.
I can carry on. Okay. I wanted to tell you about the education and health aspects.
Okay. Can have I have sent to you.
I'll tell you. The farmers lose about 4 lakh crore annually. This will be a public interest litigation of the real production cost, 4 lakh crore. Wrong formula is applied. That is A2, that is average price plus FL, that is the formula. Instead of, as recommended by the formula by Swaminathan, C2 plus 50%, that is capitalization, taking the land into input, C2 plus 50% adapted to implement Swaminathan committee report. Still, market price is less than 30% of the declared MSP. Even if this formula is accepted, it will be 30% of the declared minimum support price. So today, the farmers are losing 4 lakh crore per year. Then the mismanagement of food stock, holding 77 million ton, whereas buffer norms is 21 million. Hunger index at 103 of 117 nations. Most hungry and malnourished in the country. India is most hungry and malnourished, hunger index. At 103 of 117, we are at 103. 117 countries are listed. India, hungry and malnourished country, is at serial number 103. The manufacturing GDP, gross domestic point, was promised to be raised from 16% to GDP 25, but still stagnant. It is now 4.2. Now, petrol import, this is also a very important public interest litigation. Today, petroleum product and petroleum gas, now it is $20 per barrel. Now they are increasing estate duty and the cess. The prices which are fixed when it was 100 rupees barrel, same price. They have added to this to equalize estate duty 12% and cess another percent, because if it is cess is there, percentage must be given to the state government. So therefore they have increased in the estate duty. They did not increase in the cess. Cess portion they have to share with the state government. So therefore, the petrol import dependency, we can have our own system of without depending upon the other, the import of petroleum. We can have our dependency. We can be independent, solvent, self-sufficient. But import dependency was supposed to come down to 67%. That's what the present government promised. From 76, 76 to 67 dependency they will reduce, but it is now present 88% dependency. That is not like in America. America now today they are self-sufficient. They are not importing any petrol and petroleum product from other countries. Now, one more important factor for the affecting the farmers is vegetable oil worth 7,000 crore. Importing 5 million ton of pulses. They are importing vegetable oil 76,000 crores. 5 million tons of pulses from Canada. When our farmers grow sufficient quantity meet national need, thus depressing price for our farmers. So these are the important factors where the farmers' interest must be taken care by filing a public interest litigation, because they must get equal justice. They must get their due share that they are not getting it. So therefore, the dimension of public interest litigation should not confine only to the environmental issue and only the transparency, probity, and vulnerable section of the people to protect their rights. Even in respect of the farming section of the people, their interest must be protected, and then only we can save this country, and there will be welfare state of the country. Do you want the expansion, evolution of public interest in other countries like Pakistan, the USA, UK, Australia, South Africa? South Africa, even after the constitution was amended, they have very, very effectively laid down the law. In the case of in the Supreme Court of America, the black Americans of African origin realized the constitutional obligation. They realized their constitutional obligation. Particularly the black Americans of African origin, the Supreme Court craftsmanship and innovation is reflected in one of the most celebrated case, Brown versus Board of Education. That is, in the 98 reported in LED 873, 347 US Code 83, 1953, Supreme Court has said, in that case, the courts have carried out their investigation. In the judgment, it is observed, armed with our investigation, courts held that all Americans, including Americans of African origin, can study in all public education institutions. What has happened very recently, last week, one African race discrimination. The agitation is going on in the America. So law has been laid down long back, long back. This is Brown versus Board of Education. In the Supreme Court of America, in the case of the Association of Data Processing Service Organization, court observed that plaintiff may be granted standing whenever he or she suffers an injury, in fact, economic or otherwise. In another celebrated cases, Barros versus Jackson, the Supreme Court in 97, it has held that the unique situation in which action of state court without might result in denial of constitutional rights, in which it would be difficult, if not impossible, for the persons whose rights are asserted to present their grievance before any court. Under the peculiar circumstances of the case, we believe that reason underlie our denying standing to raise another's rights. So like this, number of judgments have been rendered by the United States of America on the question of racial issues, ethnic issues, and violation of fundamental rights of the constitution of those people. And in England, Reed versus Brown, the limited development PIL, not like America, Australia, limited. And in the case of South Africa, the constitution was adopted, a commitment to transfer society into one which was human dignity, freedom of equity. This is laid down by Supreme Court in the year 1998. So, law is taking its dimension across the world for the purpose of protecting the constitutional rights, fundamental rights, the human dignity, freedom of and the access to justice is being provided to the people in the parts of the country. I think I will hear this. Anybody has question, I can answer.
Hello. Hello.
Yes, Surendranath.
Yes, sir. Hello.
We will stop you.
Hello.
It's Jashankar. Hello. This is only floor participation with the questions. Hello. Yes. Hello, Jaya. Jaya. Hello. जी अभी जयशंकर अग्रवाल will be yeah please thanks. If there is no questions and answers, please please. If there is no questions and answers, please. Well, yeah, vote of thanks.
Justice Gopala Gowda, Honorable Justice Supreme. Can you hear me, please? Hello.
Yes, your voice is clear. No problem.
Mr. Sunil Kumar, can you hear me?
Yes.
Okay.
Please go ahead.
Yes.
Mr. Justice Sri Gopala Gowda ji, Honorable Justice Supreme Court, who is among us today to deliver a talk on the public interest litigation. It is our great privilege and honor to have Justice Gowda among us. He has delivered very illuminating talk on the subject of public interest litigation, and we feel enriched while leading this meeting today. I thank Mr. Justice Gopala Gowda for being so kind enough to be present among us today. I thank also for being in the meeting today. Thank you. Thank you.
कमाल हो गया भाई.
Thank you.
Thank you.
चल क्या रहा है ना क्या चल.
Have any
तो
questions?
ये है जयशंकर तो.
There is no question.
Yes, sir. I have a small query.
Yeah. Tell your question.
Honorable Justice Gopala Gowda, sir, very kind of you for deliberating on so elaborately on public interest litigation. Sir was mentioning at the beginning of the session that in the local courts also public interest litigation can be filed. Can you please elaborate on that a bit?
Which what regarding what?
In the local courts, there
Yes.
public interest.
This is Order 1 Rule 10. Order 1 Rule 8. Representative capacity suit.
Yes, sir. And kindly elaborate on that a bit, so that it
When
for many advocates.
civil judge junior division, you can go on file a mandatory injunction. Mandatory injunction is provided under the Specific Relief Act 1963. Mandatory injunctions are built under section 38 or 35 of the 38, I think, You can seek the mandatory injunction filing a representative suit before the court. Order 1, Rule 8. Representative suit.
Are there any precedents, sir, can quote so that we can
In fact, executive magistrate, Ratlam Municipality under the Criminal Procedure Code.
Yes, sir. Yes.
That's a public
That was a
is
very
the
good
case.
decision.
1980 Ratlam Municipality.
Yes, sir. Yes. Yes, sir. Yes.
Hmm.
Very kind of you, Honorable Sir, for obliging to elaborate on that. It will be a very useful issue, and actually the illuminating and thought-provoking deliberation is highly appreciated. Very kind of you, sir.
Thank you.
Sanjay sir. Hello.
Yes, Sunil Kumar, we are winding up.
Yes, yes, wind up.
Ah,
If there
thank
is
you.
okay, sir. Thank you very much.
Now, what do you want? What do you want? Tell me. You are asking something.
Yeah. In future also we want like this today. We need your support and need your guidance also.
Always it will be there.
Okay, sir. Thank you very much, sir. It's a great opportunity for us, all of you. Thank you very much, sir.
Webinar.
Thank you very much. Thank you for all the participants having listened patiently more than 1.5 hours.
Thank you, sir. Thank you.
Thank you. Sanjay ji, kindly wind up.
Why?
Sanjay ji, please wind up.